why he's here? Okay. And then the commission will be able to ask him questions, and then we'll speak with the principal broker, Mr. Shuford, about why he is interested in having you go through this process. And I'll ask our executive director, Caitlin Maxwell, if she'll give us a little synopsis of what the state has.
Yes, ma'am. Would you like me to proceed?
I'll give just a quick update, and then I'll turn it over to you. Before you have applicant Luke Chadwick and his principal broker, Nick Shuford. Mr. Chadwick, as of the date of this, had not yet taken the exam. The principal broker has been a broker since 2019, first licensed in 2007. The firm is the Shuford Group, LLC. A summary of the criminal disciplinary sanction is a Federal Trade Commission discipline. Mr. Chadwick's statement and a letter of recommendation can be found on your iPad.
And may I ask our legal department exactly if this was not a conviction? I'm not understanding exactly why he has to come before us.
So if you recall the rule 1260-01-.01, it states that any individual that has a conviction for a felony or a misdemeanor for theft of money, services or property, or any occupational licensing violation for any state, local, or federal body is required to appear before the commission. And so this would fall into that category.
That third category.
Yes, sir.
All right. I just want to be sure about that because I don't recall having that before. So, Mr. Chadwick, if you would, go ahead and tell us what happened, and then a little bit about yourself. What's happened since then?
Sure. And just for clarification, this wasn't a criminal proceeding. This was a civil proceeding with the Federal Trade Commission. So in 2018, I was named in a lawsuit with the Federal Trade Commission in relation to an offshore real estate development in the country of Belize. I had worked in a sales capacity for that company. It was not my company. I was never an owner of that company. I was simply a sales manager for that company for a couple of years. I had left the company in 2015, subsequently started my own real estate development, a substantial development, close to 6,000 acres, 2,800 home sites, a resort, golf course that was under construction. And in late 2018, November of 2018, I was named in this particular lawsuit for the previous company that I worked for. Really, this particular lawsuit stemmed from a prior case with the Federal Trade Commission with another person. His name was Andres Puckey. Mr. Puckey was in an unrelated business at the time. He was in a debt settlement business. I didn't have any knowledge of him, or I didn't know him at the time of that lawsuit. Subsequently, he had settled with the Federal Trade Commission in that case, and part of his settlement was that he was enjoined from specific activities. None of those activities were divulged to myself. I know that the development in question ended up part of a receivership in relation to that lawsuit. When I inquired about the nature of the lawsuit, I was provided with a copy of a settlement. That settlement was really pivotal to me in terms of my decision to move forward with them, because it was written in such a way that it said that a settlement had been concluded with the development. The developers were free to continue to develop the property, and in fact, the court and the receiver wished the developers all the best. That was my only knowledge until November of 2018. This was in 2009, by the way, when I received a copy of that prior settlement. So So really, this case stemmed from the fact that this particular individual violated a settlement agreement with the Federal Trade Commission, and unfortunately, I was one of about 25 defendants in the case between individual and corporate defendants. To answer your previous question, there was no conviction in terms of the fact that A, it was not a criminal case, and B, I ended up settling this case with the Federal Trade Commission. I had wrote a supplemental brief to the commission. Within that supplemental brief, I kind of outlined the particular instances of what really happened with this case. This case was brought under the Federal Trade Commission Act, Section 13B of the Act, and in 2021, this particular part of the FTC Act was challenged under the Supreme Court. So I felt that I really had a violation of my due process rights in relation to the case because my assets were frozen. I was unable to obtain legal counsel to defend myself in this particular case. The Supreme Court case ruled against the Federal Trade Commission 9-0 in a unanimous decision that they were not entitled to any type of asset freeze or monetary remedies. And my position is that if I was able to properly go through the process and have adequate defense, I don't know that I ever would have gone through this. I think that this case probably would have been settled. It ended up being settled. I had appealed the case to the Fourth Circuit Court of Appeals, and the minute that the Supreme Court case decision was rendered, the Federal Trade Commission came to me with an offer to settle the case. There was no admission of guilt on my part in terms of our settlement. There was no monetary sanction imposed on me as part of this case. But what I did do, which was a voluntary agreement with the Federal Trade Commission, was I agreed to move forward. The judge, by the way, did not rule that I had any type of ban on working in the real estate industry at all. However, as part of the settlement, I agreed that moving forward that I would restrict my activities to units of 4 or less in any one particular transaction. So, and that was a voluntary agreement in order to settle the case with the FTC. So there was really no conviction. This was a case that was settled with the FTC and a voluntary agreement on my part to restrict my activities to just transactions of 4 units or less. I was in full disclosure to the broker, Mr. Shuford, and in fact, I didn't know that this process even existed with the Tennessee Real Estate Commission. I had proactively reached out in regard to my own restriction to ensure that I would be granted a license with this restriction, knowing full well that I intended to comply with the restriction. Through those inquiries, it led me to Mr. Smith, who explained to me through email that there was a formal process to go through. So I submitted all the appropriate documentation, submitted my FBI background check, which showed that there was no arrest data with the FBI, no criminal convictions that I've ever had, and we're here today to hopefully answer any questions that you have in regards to this matter.
Excuse me. I would like to get some more information on exactly what it was that you were accused of. You said that it took place in Belize, but were you selling real estate in Belize to United States consumers?
That's correct, ma'am.
Okay, and you were the sales manager at that time?
I was a sales manager for a period of time.
Okay, so what was the problem? Was there deception or?
Yeah, the FTC alleged that there was deceptive, or not deceptive, but misrepresentations made. This particular development, the developer had claimed that all of the money that was generated through the sales of the development would go back into the development. Mr. Puckey, who was the main person in the development, was subsequently found to have embezzled funds from the development. I had no knowledge of that. That came after I had left the development, and so it was just in relation to a series of things that the FTC claimed that were kind of misrepresenting to consumers in regard to the development of the real estate development itself. Again, I think for a little bit of context for you all is that Mr. Puckey, which I had later found out, had gone before this particular judge on 3 other occasions. And so, I don't want to really speak for the judge other than I felt that, this was somebody that had probably already had 3 strikes with this particular judge and viewed this development and viewed the accusations of the FTC in a favorable light, given the fact that this person's credibility was pretty much shot. A simple Google Earth search, I actually went through this with the broker, Mr. Shuford. If you were to go on Google Earth and search up the development, it exists. I mean, there's a 40-acre marina, there's a beach club, there's a hotel, there's over 25 miles of infrastructure, there's many homes that have been built on the development. Kind of the idea here was this was some type of pie-in-the-sky development that didn't exist, and everybody lost their money. That actually wasn't the case. It's a legitimate bona fide development, other than for the acts of a particular individual of perhaps misappropriating some funds. I don't know that this case would have even seen the light of day, and I had no involvement in any of those things.
So what amount of money was lost by consumers because of this deception?
To be honest with you, I don't know. The FTC alleged that it was a $100 million kind of scam, if you will. The problem is that could never be eventuated. That could never really be verified from the perspective that the development is still there. In the instance of a situation where somebody made a representation that they were buying something that never existed, you could equate a loss to what the person paid, given the fact that there was nothing there. In this instance, all of those purchasers still own today their lots. The Federal Trade Commission is going through a process of creating a redress program for these people in the event that they no longer want their piece of property. That is still not been determined. And as I mentioned earlier, out of the 25 defendants, I was the only one that had no monetary sanction and no monetary judgment applied to them.
So, is this the only FTC charge that you've ever had?
Yes, ma'am.
Okay. So I'm a little bit confused. So you're coming before this commission asking to be able to test for a license. I'm not sure, and I have to ask our attorneys this. How do we grant a license to someone with a caveat that they can only sell 4 or less units at a time? Right. So he can't sell a whole development. He can't sell a building of 5. He can sell a building of 4. How do we restrict the license? And do we even have that power?
I think that you can grant him a real estate license, but the restrictions as to what he's required to do with it at that point would be solely on his principal broker to supervise him and what to supervise him to make sure that he's in compliance. Also, it's a personal responsibility for Mr. Chadwick to not violate that particular provision of this order. So that's what I think is the stipulation. So that would be what would have to take place. That's my advice.
What would be the repercussions if he sold more than a unit of more than 4 doors?
Then that would be whatever the legal repercussions come from the order that he has with the FTC. It wouldn't come from this particular commission. So if he's in violation, whatever legal happens then. So this commission can grant the license, but he has his own, requirements. So it would be the same as if, an individual is put on probation and they're required to stay. For example, we have individuals that are only required to stay in certain areas of the state. They can't leave Davidson County, can't leave Rutherford County. We're not giving them a license to stay in those counties. They know their boundaries and aren't permitted to go from there. So it's going to be a responsibility for Mr. Chadwick and for his principal broker to make sure that those requirements are kept.
I would like, if you look at that order where it talks about the 4 units, Annie, you read that as, I read it like he couldn't sell 1 unit in a new condo complex that contained more than 4 units. It's a development. Any real estate containing or involving more than 4 units or development of. You think it's a building? They're specifically talking about a 4-plex. He could sell a duplex or a 4-plex, but not
a 5-plex.
But it reads like it's if there's more than 4 units in the development almost. Because he probably didn't sell 4-plexes anyway. He was selling individual lots, but it was in a large development. You see what I'm saying?
I think from what Ms. Matlock told us that it's going to be on the applicant and his principal broker to figure that out, and it's really out of our jurisdiction.
Right, so
unless the FTC asks us to revoke his license for some reason.
Right, so we're not, typically when we, issue licenses, we're not attaching stipulations with individuals unless, we're giving someone, formal discipline with something. So it's up to their particular interpretation of the order.
Yes.
Luke,
may I just interject just a little bit? And this might be helpful for you, is that my agreement moving forward with the FTC is that I provide a report to them on an annual basis of my activities. So I think this is something that, A, I intend to be in full compliance of, but B, I think the young lady is correct in so far as this would be a situation where, via my reporting, if I was in violation of what I had agreed to with the FTC, that on an annual basis I would be reporting that to them anyhow. They would be aware of that, and I'm sure that they could then apply to the court for an injunction against me in the real estate industry. In which case, I would assume that you would be notified of that, and if that was the case with the court, then I would cease my activities and give up my license anyhow.
Yes.
Luke, I just want to kind of understand the evolution of this. So you were named in this FTC suit along with all the other defendants, and then at somewhere down the line, you pled, I guess, guilty to the charges just to settle it out. And
I didn't. No,
okay.
No, I didn't. No, I pled no admission of guilt.
Okay.
And that was the agreement. That was the agreement of part of the settlement.
All right. So that was at the trial level, and then you appealed it and the charges, you were dismissed from the suit. Is that right?
Correct. Yes, it was. Yeah, it was settled.
So whatever settlement you agreed to was dismissed at the end of the day by the court.
Yes.
Okay. Thank you.
Yes.
This is just a question, Anna. If I'm a broker of someone who has restrictions, and that agent varies from those restrictions, what's the repercussions for me as a principal broker?
So if the agent varies from the restrictions, I would think the repercussions at that point. So if it depends, I'm not sure exactly what the agreement would be with the FTC, but with this particular board, I don't think they're necessarily there might be. I don't think we're held to their standards, but I think I obviously can't give particular legal advice, but there may be other repercussions at that point if you're responsible for our laws based on whatever agreement you have in the eyes of the FTC. You might want to look at it that way, if that makes sense.
And I was asking broadly, if I have an agent
Right.
who's restricted to a certain area, too,
Correct.
that would be the same guidelines
Right.
also.
Right. There may
So-
be repercussions with the FTC or
Okay.
elsewhere. Yes.
Okay. Thank you.
So, Mr. Chadwick, you said that you own a restaurant in Australia. Where is your principal residence?
Here in Tennessee, in Thompson Station.
Do you still have a license in Nevada and California?
I don't, no. And only from the perspective that I let it lapse. There was no issues. I just ceased working in those states. In late 2018, when this case was filed, it really kind of ground my activity to a halt, given the asset freeze. And during the pandemic years in 2000 and 2021, my family and I moved to Australia, which is I'm a native of Australia, as you can probably tell. And so I've owned a lot of restaurants in my career. I opened a restaurant while I was there and had been operating that successfully until we moved back to the United States. I still own it. I have management in place running that restaurant, but I live here in Tennessee in Thompson Station.
And how long have you lived in Tennessee?
For about approximately a year now, but we've been coming back and forth.
And how do you know Mr. Shuford?
So we met. I reached out to Mr. Shuford actually prior to coming over here. I was interested in the real estate market. My wife, she's from Southeast Missouri, so we knew that when we were coming back here that we would come to this area. So I started really a kind of an informal online and by phone relationship with Mr. Shuford in terms of trying to find a property here. And we kind of struck up a friendship, and I was asking him about the real estate industry because I had aspirations to get back into the industry once I was here and settled.
Okay, Mr. Gwynn?
Yes, Mr. Chadwick, when you were selling, were you selling real estate in Belize, or were you selling partnership units in a master partnership, and then assuming you were selling real estate, are there no licenses required in Belize to sell real estate? How did that work? And then how long was it before, when you felt like things were not going well, did you sell a lot of units while you were actually there working, or what?
Yeah, so I'll try and answer those questions in order. We were selling real estate, so the development itself was a large master plan community of about 15,000 acres in total. There are a couple of thousand individual lots within that development. So we were selling lots in the development, not partnership units or anything else. A lot of those lots that I sold, individuals built homes on, and a lot of them actually live on the property today. There are no licensing requirements in the country of Belize, believe it or not. So I had been successfully licensed in Australia. I was licensed in California. I was licensed in the state of Nevada. But there are no licensing requirements in the country of Belize at all. And I forget the last question that you had. I'm sorry.
How long was it before when you felt like things were not going well, meaning people were being taken advantage of or whatever, or did you ever feel that way?
I never felt that way, to be honest with you. As I've stated this many times, Mr. Puckey and I had a really difference of opinion. So I felt that the development was the project itself, the sales, the activity of the development, things were progressing quite well. I bought my own piece of property and partnered with somebody else to do another development in the country of Belize. It should be noted that development, which was a really large 6,000 acre tract, was never sued by the FTC, even though I was working on that development at the time of being named in the suit with the prior company. But Mr. Puckey had other developments. He had a development in Costa Rica. He was doing another development in Mexico. I didn't feel that utilizing the sales team to deviate from selling the Belize development was in the best interest of the development. And that was in 2015. And as such, I left the development. There was another sales manager in place at the time. I had still been staying on in an informal capacity, I suppose, still I had relationships with people, and, my development was still in the same country, so there was, there were some similarities, and there were some mutual relationships that were still there in place. But when Mr. Puckey started to use his sales team to start selling other things, I just didn't think that was appropriate, given the fact that, that sales team had leads and had sales commissions coming in, sales revenue coming in that was subsequently being used to sell the, unrelated developments. I had a problem with that. So in 2015, I severed all ties with that development and moved on to do my own thing. And it was, well over 3 years later that this lawsuit came for that development, when I had moved on doing something else.
All right. Thank you very much.
So
No problem.
did Mr. Puckey hire you to be his sales manager?
Yes, ma'am.
And where did you live at that time?
I was living in California, Orange County, California.
Okay.
Got a question?
Questions? Mr.
Yeah.
Ferris?
Thank you, Mr. Chadwick, for sharing this information to date. Is there a time, this is Commissioner DJ Ferris, is there a time limit on this restriction, the settlement with the FTC on 4 units or less, or is that indefinitely your agreement with them?
My agreement was for 20 years, to agree to that restriction for 20 years.
Okay.
I'm able, sorry, just to further clarify, I am able at any particular time to ask for that to be removed. For me, I'm really looking to get my life back on track and get reestablished in the industry. I don't, my full intention is to abide by this restriction that I have on the license. And, in the future, maybe 5 years from now, I may seek to have that restriction waived if there's no issues at that point.
What is it that you're planning on doing with a real estate license?
I just plan on selling general real estate. So I've had really in-depth conversations with the broker, Mr. Shuford. Should I come across any particular opportunities of development size that are 4 units or more, anything more than a fourplex, that would be something that I would simply just refer over to Mr. Shuford and have him handle. My goal in moving forward in the real estate division is to just in the real estate industry rather is to simply just transact real estate, is to represent buyers and sellers in the market of individual homes predominantly. Obviously I would, given the opportunity to sell a fourplex, I would do that, but at this particular point in time, I'm predominantly looking at just single family residential.
Any other questions for Mr. Chadwick from any of the commissioners? Okay, at this time we'll move on to Mr. Shuford. Nick, good to see you.
Good morning.
Would you tell us, Nick, why it is that you want to take on this responsibility, and tell us a little bit what your plan is for training him, etc.
Sure will. Good morning, everyone. Thanks for your time today and consideration. So I met Luke. Him and his family moved here from California. They actually rented a house from me, and just really got to know them and know their character. And I think Luke and I went out to lunch, and I don't even think it was he intended on maybe bringing it up. It just naturally came up, and the story, it's a long story. And so nonetheless, I know that he was interested in getting back into the real estate industry. And, I like Luke. I respect his character. As what he went through is brutal. And, I have a growing real estate company here in town. And, based on what he wants to do and to start generating income for his family, I would totally support him. Luke's love for him to shadow me as long as possible to get him up to speed with the way we sell homes around the area. And I have full intention on, supporting him, helping train him on that. There's no ulterior motives here for, secret development deals we're going to do, So I'm very confident that we're not going to have any issues, and I'm not worried about it.
How many agents do you have in your office?
So I've got 6 licensed agents with me currently. Out of those 6, I would say 2 are really full-time, and the others have full-time jobs. So pretty selective about the agents that we onboard in the company. And I'm not looking to grow our company and, recruit a ton of agents. That's not how I'm set up. I do several different things within the real estate industry, and I'm in the trenches every day. So my setup is a little bit different than some other large brokerages.
So I'm from Williamson County, as is Mr. Shuford, and I know him and his family. I know him to be a man of high integrity. This does worry me a little bit for you, but I do have faith in him that he would definitely be watching out after this and making sure that he doesn't himself get in trouble with the FTC. He is going out on a limb by taking this agent on into his office. And I would just say, should the commission approve your application, I would want Mr. Chadwick to understand the position that he's asking Mr. Shuford to be in for him, and that Mr. Shuford is willing to accept that responsibility. I'm always saying when I speak places that if you're a principal broker, no matter what you're getting paid, you're not getting paid enough to take on the responsibility that you're taking on. And I just hope that this is a relationship that will be filled with integrity, and that you won't let Mr. Schufer down because he does have a good reputation in Williamson County. Are there any other questions that anybody would like to ask Mr. Schufer or Mr. Chadwick? Okay, Mr. Gwynn.
Anna, so the FTC, can they control what the Tennessee, in other words, if, let's say he were to sell more than 5 units or 4 and becomes at fault, he defaults on his agreement with the FTC, can they come in and say, you got to give your license up to the Tennessee Real Estate Commission? Or I don't want to get in a situation with the FTC. I don't think we do.
No. Would you like me to answer that question?
Well, let me get Anna to answer it first.
I'm sorry.
Yes.
So, like, the FTC what likely happen is we would be notified by the FTC if that were to happen, either by the FTC or by Mr. Chadwick, if there was a violation of the issue. This is just what I believe would happen. And they might request that he relinquish his license to the Tennessee Real Estate Commission. However, we do have our own disciplinary procedure that we follow. And so at that time, depending on their requirements, they may require him to relinquish his real estate license. But at that time, if I were to receive a notification from the FTC, what I would likely do is probably, open a complaint, the normal process of which we would receive and proceed that way.
Complaint based on what?
A notification that there was a violation of the order that had happened with that he has violated his standing order with the FTC regarding his real estate license.
I guess back to Joe's question earlier, I mean, we're not really giving him the license subject to anything, correct or wrong?
Right, we are not.
Yes.
And I would say this to go along with that. Not every licensee stays at the real estate company for the rest of their lives. My concern comes really is if he were to move office. Mr. Chadwick, I would like to ask you straight out, in the event that you move offices, will you pledge that you will tell wherever you go, your principal broker, about this restriction that you have on your license?
Yeah, absolutely. And in fact, just to go back to what was said about Mr. Schufert earlier, we're really here today because I had full disclosure to Nick ahead of time. I really was embroiled in this lawsuit because a particular individual was not forthcoming and did not have full transparency and disclosure of his issues in the past. My conversations with Nick in the beginning were very much that hey, I was involved in this issue. I feel that it was an unfair situation, but here's all of it. I spent probably 2 hours disclosing all of that to him. I don't want to make light of this, but when you go through something like this that I went through with the Federal Trade Commission, you never want to go through that again. And so my intention is to have integrity, is to act with integrity and professionalism. I have no issue with abiding by what I had agreed to. I agreed to it. I'm a person of honor. I intend to agree to it. And if your request of me is that that I have full disclosure for any potential broker in the past. I have absolutely 100% agreement in that.
Thank you. I'd like to make a motion to approve this candidate.
Second.
We have a motion to approve this candidate by Mr. Ferris and a second by Ms. Torbett. Any other discussion? All right. All those in favor say aye.
Aye.
All those opposed say no. That motion carries unanimously, 9-0. Mr. Chadwick, we're expecting great things from you, and I just ask you that you never let Nick down, and never let yourself down, more importantly.
Yes, ma'am. Thank you very much. I appreciate all of your consideration.
Thank you all.
Great. Have a waiver request. It's a medical waiver request by Mr. Joseph Walters. Ms. Maxwell, will you read that into the record, please?
Yes, and this one is a medical waiver request and a request for a penalty waiver of the E&O. So the licensee's name is Joseph Walters. His license expiration date is May 4th, 2023. He had an E&O lapse this January with the E&O renewals, and has now gotten the E&O, but is asking for a waiver from the $400 penalty. And so
He's paid in full on
he is not paid yet for the E&O penalty. He reached out with, you'll see in your packet a note from him, and then a note from his doctor.
This is showing he's not gotten his education also.
He doesn't need it yet because he doesn't expire until another month. I can double check that, but he still has another month on the education requirement.
So he does have E&O, he just wants his penalty waived, or he doesn't have E&O?
He has E&O now, but the $400 penalty is the penalty for letting it lapse and then having a gap in coverage.
How long did it lapse?
Let me look. Definitely over 30 days, because that's when the penalties begin to accrue.
So he was licensed in 2021. I'm just trying to get the time frame on when he would have first paid for E&O.
So his so all licensees that failed to maintain the E&O were suspended from or were suspended on January 31st. And so then they had until March 2nd, I believe. And so it looks like he did just miss that deadline, and his policy became effective March 13th.
So he was issued his license in 21.
Yeah, so his previous policy was May 3rd, 2021 until 1/1/2023. So
Okay.
this would have been his first renewal for his insurance, correct?
Was his principal also charged?
He has probably been, the way we do that is we open the complaint against the PB once the affiliate, once we know the terms of the affiliate's insurance, because theirs is also mimicked by $200 for backdating and $400 for not backdating up until 120 days. And so there's likely been a complaint opened against the PB that we, yeah.
So it takes 120 days to get to 400?
No. Once your E&O has been suspended for over 30 days, you have 30 days without a penalty.
Okay.
So the suspension we run the suspension monthly, but the 2023 January odd years are big years because that's when the state contracted policy renews. So the suspension ran on January 31st, and then from that date, licensees had 30 days. We mail out a letter to them.
So that would have been February, end of February, let's call
March 2nd.
March 2nd. He could have paid what?
Nothing.
Zero. Okay, then what? So
then by statute, after 30 days of being in suspension, you either pay $200 or $400, and it's based on whether there's a lapse in your coverage. So
if there's a lapse, it doubles?
If there's a lapse, it's $400, whereas if there is no lapse,
it's $200.
It's $200. Mm-hmm. They get the gap insurance, yeah.
He didn't.
He did not. Yes, so he got his policy pretty much immediately following when the penalties.
So he was really 12 days out from not having a penalty.
Yes.
I'll make a motion to waive.
Second.
Okay, we have a motion by, let's see, we have a motion by Mr. Begley, and we have a second by Ms. Torbett. Any other discussion? All those in favor say aye.
Aye.
Any opposed say no. That motion carries unanimously 9-0. Okay.
If we have Laura Martin in the audience, we have a new attorney that's starting, one that you met last month, and then a new one that will be taking Jeff's position. And so we were just going to quickly introduce while she was here.
Good morning, commissioners.
Morning.
How are you? So I'm really excited. I wanted to introduce, this is Ariel Carter, and she just started with the department, I guess 2 weeks ago now, 1 week ago now. And she is going to be a part of your legal team as a litigator. Ariel moved to Middle Tennessee recently from the Knoxville area where she was working at the public defender's office. So we're really excited to have more litigation experience on our team. And probably starting next month, she'll be doing some cases with you guys. So I just wanted to give you a chance to see her and meet her and maybe ask her some questions if you would like. But yeah, this is Ariel. Make sure this is.
Hi, nice to meet everyone.
Yeah. Congratulations. Welcome to TREC.
No, I have a question. I always have a question.
I figured that's why I was, yeah.
So I know Jeff lived in Knoxville. Are you living in Nashville or do you live in Knoxville?
I live in Nashville.
Okay, great. All right. Well, we hope you enjoy your time here, and we look forward to working with you.
Thank you.
And I think all of you were here last month, but I introduced Kim, who is now fully immersed in the world of TREC litigation. So anyway, we have all three attorneys for you. This is your legal dream team, and we're really excited. So
Need all the attorneys with you.
yes, but yes, thank you for having us.
Thank you. Welcome, Ariel.
Yeah, just a note for those watching and those attending, thank you all for being here. The legal team on behalf of the state that works and serves this commission is incredible. Their wisdom, their candor, their just their overall abilities is marked, and we could not do this without them. So thank you all, and welcome, Ariel.
You're so welcome.
I'll send you that.
And for those of you in the audience, if you could only see Anna's face when things happen, she's you don't wonder what she's thinking.
I'm never rolling my eyes at it.
Okay, so the next thing on our agenda is the Education Director's Report. Mr. E. Ross White.
Good morning, Madam
morning.
Chair, members of the Commission. Hope everybody's doing well this morning. It's a beautiful day. We've got a fairly large education agenda this morning, and I turn your attention to that. I would present that to you this morning after review for your approval. I've reviewed all the new providers, the instructors, and their courses. I present those to you A1 through A44.
Anyone on the committee have a question for Mr. White about any of these courses before we take a vote to approve them or not? Any questions? Great job, Mr. White.
I move to approve.
Second.
All right, we have a motion to approve by Mr. Ferris and a second by Mr. Any discussion? All those in favor say aye.
Aye.
All those opposed say no. That motion carries unanimously, 9-0.
Thank you, Madam Chair.
And now on to our instructors.
Again, this morning I'll present to you the instructors. I believe we have 4 this morning for your review and potential approval.
Have any questions about any of these new instructors? As on this test, that all their qualifications have been met. Questions?
Move to approve.
All right, we have a motion to approve by Mr. Ferris and a second by Ms. Tucker. Any other discussion? All those in favor say aye.
Aye.
Any opposed say no. That motion carries unanimously, 9-0. Mr. White.
Thank you, Madam Chair.
Great job. We couldn't do it without you, that's for sure.
Thank you so much.
Thank you. Okay, and then next to our Executive Director's report, Ms. Maxwell.
Okay, I just have a quick update for the commission on some recent items. One being the PSI test review. Steve and DJ, as well as Anna, myself, and Ross, as well as 2 outside subject matter experts. We had Jim Oakley from Knoxville and Katie Townsend from the West Tennessee area participate yesterday with PSI in reviewing the state portion of the exam. It was a long day, but I think it went well. We reviewed all questions that either had law or rule changes, and then in addition we reviewed any questions that are not performing well on the test to see if potentially they're confusing. I was surprised to find out that they are not trying to trick anyone, and so we reviewed some of the questions that potentially could have been viewed as confusing, and then also some outdated questions on, what was it, Ross? Bank savings and loans.
Savings and loans.
Savings and loans.
Yeah. Photocopy.
Photocopy, yes. So hopefully those changes to the state exam will be implemented, I think she said by July. And so we'll see those. And I was also surprised to learn that if any test taker puts a comment on any particular question within the exam, they actually do review those. And so if any, not that, you would take the test and put a comment on every question, you might not meet your time requirement there, but those actually do get reviewed. And we reviewed a handful of those and listened to the feedback on those. So just something to note. But overall went well, and happy to answer any questions that anybody has about that.
I want to say thank you to those of you who served TREC by doing this. I've done it before, and it's very arduous, I know, and it's a long day, a very long day. So I want to thank you first and foremost. I wanted to ask about, I have also served on the national part of the test too. Was there any discussion about how low the rates are in the state of Tennessee on the national part? We're now at, I think it was 61% failing the national part and for the affiliate broker.
So there was a little bit of talk about that, and she did say that what she has seen, and anybody else feel free to chime in, is some states, their providers are directly mimicking the way that the exam is written and mimicking the exact number of questions based on each section, based on the exam in their coursework. That's not a requirement to my knowledge in Tennessee. So there was that. And then I believe there was also mentioned that they are looking at the national exam, and I believe they're implementing changes to that hopefully by October.
And honestly, from what I have found at Arello, it's not just the state of Tennessee that are having low passing percentages. It's nationwide, and it's almost always on the national part, not the state part. So, but that 61%, I always look at that each month when you give us these records, and that's just startling to me. 61% failed.
It has gone down, I believe, I feel like when I started with the commission 5 years ago, it was around 50%. There has been the addition of being able to take the remote exam. And I can try to get those scores for you next month of the breakdown of the pass rate in person versus the pass rate remotely. We had a little bit of discussion about that. I think it depends on the test taker. I know one of the outside members, she has a lot of agents, a lot of new agents, and she mentioned, some of her agents do better on the remote because they get really distracted by people making noise in the test room. Whereas in the comfort of your home, you don't have those other test takers. So I think it seemed to be more by test taker than by.
I didn't even know we could take it remotely. I'm worried about people that have cheat sheets and stuff laying around at home. Start doing it.
Oh yes, we COVID. Yes, yeah. That was a big push during COVID, but it's very secure. They have to show everything. I would say there's monitors, and I actually get a notification anytime there's any sort of question about cheating. I don't bring them to you because they're banned from taking the test unless they wanted to come back. And then if they wanted to come back, then I would present them to you to determine if you were okay with them proceeding with the test. Mm-hmm. Yes. Yeah. PSI bans them. And we had one, it was in person actually at the test site, and they brought in a camera. It was a small little camera in their shorts, and PSI caught that. Yeah. Yeah. I saw the video footage. Yes.
I asked her if they had any stats on the average age of the person taking the test, thinking that maybe Tennessee had a younger age and that you potentially did better on a test if you were older and had a little bit more maturity, meaning maybe you'd work 10 years doing something else. She didn't have any stats on that, and it kind of got blown out of the water a little bit with it just depends on the test taker. But maybe that's a part of the answer. I don't know. But it is alarmingly low.
They also have
just a few comments and takeaways, and I didn't want to jump ahead of Caitlin, but this discussion yesterday was all about the Tennessee portion of the exam, and it was interesting in that they showed us how the brokers did versus the affiliate brokers, percentage-wise, and so each question that we went over had some degree of issue as per the PSI representative, and I guess we went over at least 40.
Yeah, I think it might have been a little bit more than that, but around that amount.
So it was a goodly amount. The point is that this is a pick out of 4 best answers. You read the description. Sometimes whoever reads it as the student is going to have to say, I've got a distractor. One of the 4 would be something it wouldn't be, but they'd have to have a knowledge overall. Sometimes in the reading part to have, okay, if this works, then I've got to know this and this and this. So it's not very simple. I mean, it's very, but it should be. I think the degree of difficulty is probably the way it should be. However, as a person who personally had problems with tests myself back in the day, I would think that maybe our providers, and the takeaway that I had, would come up with a course that's a test-taking course, something that would help folks maybe along the way. But as it is, we went over everything, and then the discussion was all about the minimal competence. That's kind of what our goal was, to establish that if this question is a good question, it will enable that person to have at least minimal competence in what they do and in the industry. So it was very interesting.
What about the people, maybe they have dyslexia and they test great verbally, but they don't written? Do we have any accommodations for anybody if that occurs?
Yeah, they can request an accommodation by PSI. It's on the PSI bulletin. I think it's one of the last pages. You submit a request for.
PSI contract renew?
I believe it's 2024. So we'll start that process in the fall.
Caitlin, do you have any update on the getting the real estate classes as part of the curriculum in schools? Did y'all talk about that last week?
So I'm supposed to have a meeting about that tomorrow. Right now, it could be offered, like if you had a student that wanted to take it in one of those counties, they could take it today. But as far as getting it in the curriculum, my contact at Education emailed me yesterday or earlier this week and said she believes it can start being offered this fall. So I don't have an official update, but I'm on a call with them tomorrow.
Okay.
And so hopefully I'll have a good update in May. I've been trying to explore the avenue of it just being part of like an elective or like a club extracurricular. So that's another option I'm exploring.
In that vein, how are the schools going to be notified that this is available, and is there going to be some conversation about who the instructors are going to be? And
that's the barrier I'm running into right now.
Okay.
Is I reached out to the schools like last year, but I don't have a good contact for the schools. So I think my contact just kind of went, or my communication just went nowhere. And so I met with Clay County last summer, and they said, get this as part of the curriculum where students can take it in the classroom. So that's basically what I've been trying to do ever since then. And I've been working with the Department of Education.
That's something, maybe you don't know this, but is that something that eventually has to go to the county school boards for discussion?
It has to go through the board at Department of Education.
Yeah.
Yes.
They approve it, then it's available statewide, or does it have to be that?
So our proposition as part of the governor's priority on distressed counties was only for the distressed counties, because the way that the contract was written is to fund this out of our education and recovery account. So I don't know that it would never be statewide, but right now it was written for those distressed counties and those schools and those students.
If I may, Director Maxwell, my husband is actually the CTE director for Cheatham County.
Oh, there we go.
And he would love to
Okay, there we go. I'm glad you asked this question.
You have a good contact.
There we go.
If you can get one, then your
That's all you
chances
need.
of getting
Yeah.
another one go way up.
I really like the idea. So hopefully,
Yes.
Yeah.
Yes. Everybody that I talk to likes the idea. It's just
who's going to do the work to get it started,
Funding.
right?
Yeah.
No, well, the funding's there.
but the funding's there. Yes. Yeah. There's just and not surprisingly, you can't just start offering a course
Yeah, you
in
can't
the
parachute it in, no.
yeah.
I guess, is there, what are the metrics to decide what a distressed county is? Do you know that?
Yeah. Yes.
Okay.
It's not set by me, but it does fluctuate. I know ECD is keeping up with the counties that are distressed. I think right now it's 10. I think when the governor started, it was around 14 or so. So there's distressed, at risk, and then none of those. So it's kind of constantly fluctuating. I can send you the link though, so you can kind of see.
Sure.
Yeah. Any other? Yes.
Refresh my memory on how long a person has after they apply to pass the test, or is there a time?
So they don't apply first.
Right.
They don't apply until they test.
So
once they've taken the test, they have 6 months to pass both portions. So we sometimes run into that where
6
somebody,
months.
yes, they have to pass both portions and submit it to us within 6 months.
So we've had 1,400 applications this year, and we've tested 3,000 roughly. So how does that? I'm trying to think. So we're testing a lot more people than are applying.
Yes,
Is that because
but that's
multiple
not
attempts or what?
So that's not necessarily. So that table I have for you of initial applications are truly initial applications. This right here would also include any retest, reapply applicant. Does that make sense? If you let your license expire over a year, then you fall into that retest category where you have to take the exam as well again because you're past that 1 year mark. And so what you see up above is only for those true initial first time applicants.
Okay.
But yes, I think you do have people that have to take the exam multiple times.
Do we know how many take it once and fail and then never take it again, or is that?
We don't know that.
Okay.
No. No, but that does include multiple retests.
3,000.
Yes.
What's the maximum number of times you can read?
That is set by PSI. I don't think there's a maximum. I think if you fail it once, you can take it again. But then I think after you fail it twice, they make you wait, I think 30 days. And so there is some of that. So we do run into people passing the state. I just actually ran into this. They pass the state. They wait until almost the end of the 6 months to retake the national. And then that fails, and then they're stuck retaking both after that. So
That 2 week or that hold off from after you fail twice is a PSI thing, so you don't map the test.
that's my assumption. Yes,
Be able to gain
is
it a
that
little bit.
yes, they have some of those security measures in place, so you can't just go in there every day,
Yeah,
get all the answers and the questions, and yeah, I think it's security purposes. So the only other update I had for the commission was just about the May meeting. We will be in Jackson. We'll send out the details of that. But it is on May 10th, which is a Wednesday. It's at the same county courthouse that it's been previously. Pretty much all the same details as years past, but we'll resend that. And the hearing that was supposed to be today has now been continued to that date at 12:30. as of now.
I'll let Caitlin our discussion at dinner last night that there is some concern as to setting a time of 12:30 and it going into the night. Originally, we had Wednesday was our cases, and on Thursday was our hearings. But because we've implemented a consent agenda, our time is much shorter here than what it used to be. And so that's why the state is wanting to do them at the. Obviously, Jackson probably have to be the possibility of. I know Anna is not going to tell us how long it's going to go because the last time she didn't think it would take very long. We went really long. So there's no way for her to even judge that. But she might know the amount of witnesses that will be planning to come and have some idea about it. A lot of times they settle at the last minute also.
Right. So I wanted to clarify why this hearing was set for the day of for both meeting dates. So it was set originally today because we had the PSI testing, and we didn't want to make the commissioners that had to stay go for 3 days. And for the May meeting, it was set the same day because we have a time conflict with Director Maxwell. So we need one date.
Well, I mean, I could do an attestation.
Well, yes, but also I do want to remind you that the time that we had the long meeting, if you recall, it was on WebEx during COVID, and I don't anticipate to have the same issues. Where we do have, I'm calling Director Maxwell and 2 individuals, but one of the individuals, the respondent, is also calling, and they're only also calling the respondent. So I don't anticipate the hearing to go that long, to be like late into the night. But that is usually the second day. So otherwise, we would set it the second day.
A judge will be coming from Nashville to there? Or?
Yes, there is a rotating panel of judges. So a judge will come to the hearing for the date. The hearing was continued because one of our witnesses was ill and unable to travel to Nashville for the hearing today.
We push it till June back here.
Well, the parties are all located in West Tennessee.
So I guess my question is, if it starts at 12:30, is that going to require a second night stay in Jackson?
It depends,
because that's a long drive.
Yeah,
from Jackson to Johnson
like
City.
Me, you can't see after dark to drive, so we just have to be prepared that it might be 2 nights, and if it is, it is. If it isn't, it's not.
Yeah, anybody would be eligible to stay the second night, and that would be if it was that day or if it was the next day.
I'm anticipating a second night stay.
This is the 10th, May 10th.
The 10th. Right. So I'm not into, I would think that it would be like an afternoon, maybe around 4 or 5. So for you to drive back to Johnson, I don't think that's logical for that evening.
I'm in Panama.
Right.
So for instance, right now it's 9:51, and we're about to start our legal cases. I was worried about today in that what if we finished at 10:30 and the hearing wasn't until 1? will the people be in place where that they can start earlier if we finish with our meeting earlier?
It wouldn't, because, for example, like the court reporter wouldn't be scheduled to arrive until a certain time, and the judge and the other parties. So like that was like one of the other times, is like we were trying to gauge what time we would be ready. But again, you know, it's very dependent upon how many cases are pulled for the legal report, how many informal appearances that we have. So that was part of my other reason for pushing it up 30 minutes, thinking that maybe one was too late to send it back. And then I was hesitant setting it at 12. So I'm trying to like gauge what time would be enough time to get it, so we're not wasting too much time in between the meeting and the hearing.
So we could, Marcia, could we theoretically like have the hearing at 11, and then if we need to continue our business after the hearing, you know what I'm saying? We could, this meeting, we could postpone
But she's
time
already
for.
booked them for 12:30.
Like I've set the hearing for 12:30. So if we're needing to set the hearing, I mean, if the hearing time needs to change, to have
Yeah, I was going to pose the possibility of doing that sooner, and you know, some of the reports that we do, either doing those in June, anything we can push to June just to put an emphasis on the hearing.
we'll need to have a legal report, because like case metrics. So
A chance of.
I can.
That means though that the judge and the court reporter will.
I mean, I
probably
can
have to
propose
spend the night
changing.
there.
I can propose changing the meeting, the hearing time. I don't know how much that'll assist us if the hearing runs long. I don't.
Speed and deliberation of over the legal agenda where we can.
We cannot control.
We cannot control the hearing. Yeah, like if we go.
It's up to the judge.
It's Strawberry Festival week.
I
You need some
started saying,
entertainment.
I could go to the Strawberry
Come
Festival.
on, y'all.
Commissioner Jack.
Our meeting Wednesday afternoon and the hearing Thursday morning. That way we could drive down Wednesday for our meeting, and hopefully the hearing wouldn't last very long Thursday morning.
We normally do go in the night before for like typically if we're going to be out of town, even like I'll do an outreach for that area. So I think we could look into doing the hearing earlier on Wednesday.
Well, part of it is that there are other parties involved. You got the respondent that has to agree to the time change.
Do you want me to look into changing the date on Thursday? We can look into changing the date on to Thursday morning. I mean, regardless, it's probably going to be a second day. Like you're gonna have to say 2 nights. So it's like.
Yeah.
So.
Yeah. I think
I would make it hard on.
yes, you guys have gotten out of the hearing out of the practice of hearings. Everybody's complaining now about 2 nights.
Just like at first, we don't have hearings. Now there's a hearing. Oh, the hearing's going to be long.
I wouldn't mind the 2 nights here in Nashville. It's just it's so far away from East Tennessee.
And I'm glad it's not in Memphis then.
Yeah.
Well,
It's not much further. It's not much further than Memphis.
And looking ahead, you've got 2 new litigators here that are going to be setting a lot of hearings. So I'm very interested in this discussion. And when would you like me to set hearings moving forward? And Ms. Carter. So, well,
I guess I would just prefer the hearings be here in Nashville.
Well, I don't think we should say that because, and I understand what you're saying, but I don't think we should just blanketly say we're not having them anywhere but Nashville, because it puts an added burden on the people from West Tennessee and East Tennessee if they're always in Nashville.
But if they miss the West Tennessee date, then they got to wait a year, or east. So
Or drive to Nashville.
correct.
Yeah, but there's also the reality that state government is in Nashville.
For me, like, one of the reasons that we like travel to West Tennessee is like we travel there to have our meetings. And so all of the parties, like opposing counsel or respondent, all of the witnesses are located in West Tennessee. That's where they live. And so my priority is also, this is a case that we want to settle and end. If you want me to move it another date to June, we can do it. That's a possibility, but that's just more time that's going to elapse. It's a possibility that can be done. I'll file another motion to continue for another month. That's a possibility.
Don't do that. I mean,
but I'm just letting you know, like, that can happen. But like we do have 2 dates. Like, if we want to move the hearing to like the Thursday morning, I can adjust and do the Thursday morning. I can do that as well.
If it's 2 days, I would rather just stay long Wednesday and then get up early and leave Thursday. I mean, it drags it out.
I'm just like, I want to work with your schedule and be accommodating, but I also want to make sure that I am making my best effort to close cases for you all as well, because I've been trying to get this matter before you for a long time, and I would have loved to have it here today, but my witness got sick and the opposing counsel wouldn't let me have them testify via video conference. And so that was the issue.
So I would say this, that going forward, when you set hearings, I think that I'm speaking for myself. When we've been here since 8:30 and we're still going at 6:30 and we're determining someone's fate for instance, are they going to be revoking their license or not? I would rather the hearings take place in the mornings when we're fresh than late in the afternoon when our brains are fried. And I think it would help the person coming before us to have those hearings in the morning versus having them in the afternoon.
But, I think as commissioners, every month we have the option to whether to make the trip to Nashville or to East Tennessee or to West Tennessee. So make a decision that suits your life. We only need 5 people for a quorum. So,
and the state mandates, the reason we go to East Tennessee and to West Tennessee is the state mandates that we do that every year. So that's why we do it. And it is to be accommodating to those people who are having to drive so far. Every month, I always think about you guys driving from Johnson City or driving from Memphis, and the what that takes for y'all to do that once a month for 5 years at minimum. And I appreciate all of you doing it, because I'm just right down the road in Williamson County, and so but your commitment is actually greater than mine, because you do have to do that. And it's a safety matter and everything. So I do appreciate y'all doing that. I think at this point, we probably should just leave it as it is. And as they said, get through it and they more, but in the future to try and have those hearings in the mornings versus in the afternoon for the sake of the person coming before us at those hearings. Because we have time to look over the agenda and the legal cases for the afternoon, whereas with the hearings, we don't know who's coming before it. We don't know anything about it. So we need to be fresh at those hearings more than we do what we do in the afternoon.
So what you're saying is have it 100%. Like it's usually on the schedule. So we have our meeting on Wednesday and Thursday's left open for a hearing. And so start a new day for the hearing. I would rather do that and know that I'm staying for 2 days than, well, if it's not too late, I'll get on the road. I would just rather have 1 day for this.
Well, I'm saying let's do the hearings on Wednesday mornings, do our meeting on Wednesday afternoon, and then go home Thursday morning.
But if you leave it like it is now, and let's say the meeting's over at 5, y'all can make it back to Nashville part of the way. Make sure. That's what I did when we were in East Tennessee. I came back to Nashville and made the drive the next day a lot better. And you knock out a few miles as opposed to Jackson to Johnson City in one fell swoop. I mean, it's a matter of like, do I spend the night in Jackson or Nashville? If I were y'all, I'd rather stay in Nashville. No offense to Jackson. It doesn't help this.
I know.
In case you didn't hear.
Okay, so.
I think we did.
You. Y'all hear the opinion, so I mean.
Live with what we've got right now.
Yes, live with what we've got, but going forward, I would prefer if they're in Nashville to keep it like it is always on our. Straight up that we have 2 days.
We must stay 3 days. Because Thursday.
There's surely not going to be another one that goes from 8:30 to 7:30.
You never know. Yeah, there's no way that Anna can.
Let's see how this one goes. We haven't had one in person in a while. So let's just see how it goes.
I think the in person is the whole.
So
You could make all hearings go in front of ALJ alone and then just not even deal with them. That's what some commissions do. They have all of them go just ALJ alone.
What does the staff prefer?
I don't know. I don't know.
Make a motion to move on.
Second.
I'm not for letting an ALJ to determine if a person's license is revoked because they're not real estate licensee. They don't know. It's. I mean, we have great attorneys, but they're not realtors. And you know, sometimes we have to explain things to them. Well, in the real world of real estate, this is what happens. So I would rather not turn that over to just a judge. Okay, so it's 10 o'clock now. Were we finished with the executive director's report?
Yes.
Okay, so we're going to take a 10-minute break, and then we're going to come back and do the legal consent agenda. For those of you in the audience, the men's restroom is right across the hall. The women's is around the other side of the building, as is the break room where there's cold drinks and snacks and stuff. So we'll be back here at 10:15, please.
Interesting. Actors.
Mute.
What's the percentage?
Yeah, I got up roaring this morning, like, wow, beautiful. Sun was gorgeous. Sun just turned the big 20 a few years ago there, but they happen quick. Yeah. Well, those 7 years, I'll tell you what, man, from 15 to 22, they got real quick. Yeah. 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 It makes them start thinking, ooh, an old man. Yeah. Oh, absolutely. Yeah. There's that. Oh, I got a number 2 coming.
All right. So our legal consent agenda. Today we have pulled the following cases off of the consent agenda. Cases 8, 11, 12, 15, 16, 17, 21, 27, 28, and 32. So is there a motion that we pull those from the consent agenda? Okay, we have a motion by let's see, that was John Moffitt, and a second by Mr. Gwen. All those in favor say aye.
Aye.
All those opposed? That motion carries unanimously. All right, case number 8 was pulled by Ms. Smith.
Okay, my question on this one was the complaint. Let me back up. Seems that there's an advertising issue, but there are also, and I recommend, and I understand that, but I also was concerned because it said the respondent is advertising business for sale and no real property. Do we have any concerns there?
For advertising a fictitious piece of property?
No, they're advertising the business for sale, but they're not advertising real property for sale.
Oh.
So, but then it goes on to talk about some some advertising. So there is a justification for the advertising. I just wondered, did we have justification for selling businesses?
We don't have any jurisdiction.
We don't
over
have any
selling a
jurisdiction.
business.
We don't. Okay.
So advertising is the issue on this one.
Right. I just wanted to be clear.
It's on social
Right.
media.
No, it was like a business. So I was also kind of confused why it was submitted by the complainant, as there was no real property attached.
Right.
And it was it was an advertising issue. So that was one of the other reasons that I dismissed the complaint.
Okay. I move to accept council's recommendation.
Second.
All right, we have a motion by Ms. Smith and all those in favor say aye.
Aye.
Any opposed say no. That motion carries.
On this one, it said the respondent did not provide a response. Is there any issues with that?
They're unlicensed.
They're
so
unlicensed.
They don't have to.
Okay. Move to accept council's recommendation.
Second.
All right, we have a motion by Ms. Smith and a second by Mr. Moffitt. All those in favor say aye.
Aye.
All those opposed, motion carries 9-0.
Okay, same issue on number 12, and so I'm going to accept council's recommendation.
Okay, we have a proper motion by Ms. Smith and a second by Mr. D.
Well, no, number 12 is
Discuss. Let's discuss.
Oh, I'm sorry. Let me go back to my number 12.
So number 12 is a little bit different.
Yes, I apologize.
Both you and Chair Frank. So this one's a little different. So I'll just read it. It's very brief. So it's not really a complaint. It's more just kind of like an inquiry, but it came in through the complaint process. So we put it on the legal report for like general discussion. So the complainant is a principal broker. Complainant provides that licensees are using an app to hire and pay other licensees directly for showing listings for them. The app allows licensees to pay other licensees directly and consequently receive funds from the app for providing real estate services. The complaint was referred directly to the legal division. The commission staff has received several inquiries related to the use of this app. The app connects buyers agents with showing agents that are willing to show listed properties for a fee. Presently, council is not in receipt of any complaints related to the app. However, following a conversation directly related that this matter is being brought to the commission for general discussion and thoughts on the permissibility of the use of the app in Tennessee. So I'm not asking for like any general action to be taken, but we've had a lot of inquiries related to the app. This is probably something that could have been just put on commission discussion. So if we want to come back to it later, we can. But it's something that I'm not sure maybe you guys are familiar with. But we've had a lot of questions about it, and we just wanted to know generally your thoughts on the business model.
Is anybody familiar on the commission with this app? Oh, tell us anything.
I didn't want to name the app, but I mean,
So it's an app that the agents can go on and register themselves as showing agents. And then say you have a listing in Knoxville and you don't want to drive up there to open it. You go on your app and there's somebody who'll pick it up like an Uber driver almost, picks it up for $49. They'll go show it for you. The problem is I've had a call from a broker or two on this. The problem they have with it is in Tennessee, no agent's supposed to be paid except from their brokerage, right?
A commission.
A commission. Well, anything real estate related, I would presume. So they're getting paid from the app. So it's not going through the brokerage. That's the issue. Am I correct, Anna?
So one of the issues is that they're receiving funds from directly from the app. And so if you remember previously, we did submit an AG's opinion asking about, whether money has to come directly from the principal broker. And we said that, if the principal broker were to delegate that to a third party to to receive that money, that would
Writing.
be in writing, that would be okay. But obviously, like this app, you're getting funds. That's not really kind of what's happening here. And so do you want to talk about some of the inquiries you've?
I think the other sort of question is like if you allow somebody else to show your listing, let's say they forget to lock the door and then something happens to the property, it's like who is really responsible? Is it the agent that's listing the property or is it who they let show the property? It's just, I think there's some questions.
Some other questions that come with the general responsibility that comes with it. So we've had some questions that have come in from different agents across the state asking, can we use this? Is this okay? And so since we had this come in through the complaint process, we thought, since we're getting a lot of inquiries, we would bring it before you all, just like to see what your thoughts were.
I kind of think this is a disclosure question. I would think if the principal broker agrees to allow his agents to be paid by a third party in writing, then I think the listing agent should disclose to their client that it's possible that they're going to have another licensee show their house at some point if the showing is scheduled, so that the consumer knows that that's a possibility as well, and they can opt out of it if they want to at that point.
And does it have to be a licensee?
Yes.
But yeah,
so you have to provide your license number to this app?
I don't think there's. I don't think there's a disclosure to the seller because it's just another licensed agent. I mean, there's no, unless you've prohibited certain licensed agents from being in there, it's just another licensed agent that's going to show the home. So it's not that I'm going to go show it. It's that I've just referred it out to DJ in Nashville or something. The question also, I think we'll have some issues with, whose client is it at that point? Because if I'm in Kingsport and you send them to me and they don't buy that particular house, I'll have the opportunity to maybe sell them a different house, and then they'll be wanting a referral agreement. I mean, it's like anything else complicated.
If you go through and sign up in the app, is all that laid out in the app, or it's just vague?
It seems like it's just a cash exchange app. It wouldn't have that layer of complexity to it.
And the only fees that are getting paid are just the showing fee, right? It's not like so it's a flat fee if you'll show this.
It's the same thing if somebody says, I need a CMA report, a comparative market analysis report, and will you get me one? And I say, well, I will for $100. So is that paying me a commission? Is what we're regulating the commission or a business practice? To me is the question.
I would say I don't know a lot about this, but as a public member, it seems like it would be a helpful tool to the general public to be able to get their property shown more.
I think from the way I read the case, this is primarily used if I am a buyer's broker and I cannot get to a house to show my client that property. I put it out there, and it's almost like an Uber for my buyer. It's not for my listing clients so much. I've never used this app. I had questions about it too. I'm glad it was pulled by 2 of our members because of the disclosure. I think, Jeff, it warrants, and it's different than a car ride.
Yeah, I would think the consumer would want the option to opt out of it. If I'm listing a house, if it's my house that's on sale, I kind of want to know who's coming in and out.
Well, the listing agent, I'm sure there's got to be a way of letting the listing agent know who's showing the house through the app. They would have to have notice of it.
Well, the listing agent gets notified, I would think, if they have the lockbox. They get a notification whenever it's open. And,
yeah, I
and
think.
who's done it.
Sorry to interrupt. I just think if we could figure out a way to appease the part of our state law where licensees are paid through their broker, I'm fine with the app being used as a tool, because in real practice, if I cannot be at every house showing, I've got a colleague with my firm or another firm in rare cases, but they'll show it. And, smart practice is to let the listing agent know, hey, Jeff, my client is going to see your listing at Main Street. A colleague in my office you will see come up as the showing request. It won't be me. That's just smart and simple and obvious to me, but
Professionalism requires that we be
right
about it.
Right.
But as we were talking earlier about the state of Tennessee being 8 hours from Memphis to Johnson City, we're a very spread out state, and you have a listing in Johnson City, and you can have a listing. You got a cousin that lives in Memphis, and you can say, I can list that, no problem. But you don't live there, but I've got an app I can sign up to, and they'll show it for me. I don't know. It's kind of muddying the water a little bit in that, what is your responsibility for this listing, whether it's a cousin or
yeah, again, I think it's, sorry, Steve.
Joe, do you know if the app transfers money? In other words, is it like Venmo, or do you know? Why don't they just use Venmo? In other words, if they're not blocking people from registering in the app that are not licensed, which you said that's correct, right? There's no place to plug in your...
Yeah, the app's benefit's not the transfer of the funds. The app's benefit is hooking up the person that wants to find someone to show the property and finding a licensed agent to show the property. So I think you register, there's a you register, and then I'm not sure how the money's transferred, but in today's world, I've been in the business for a while. Used to, if I had a busy day today and a new house came on the market and somebody wanted to see it at 3:00 today, I've got a full day. But if I don't show it to them today, I'm doing them a disservice, because it's probably going to get multiple offers and be gone tomorrow. So you can't be in two places one time. So you either have to find somebody in your office, and if not, you got this little app, and it just shows it. And it's a licensed agent. It would be just like the other client calling this agent and going to see it. So yeah,
if they're licensed, I don't see so much problem with it. But if they're not licensed, if that's a part of the app that they have to put in their Tennessee license number, and guess what? People steal Tennessee license numbers. People make up Tennessee license numbers. There would have to be some way that the app could verify.
Well, they'll have to have a lockbox key.
Yeah. Is there precedence? Have you checked other states to see how they've handled this?
I've not.
Because I would think we're not the only state. So
we're going to Boston, some of us, at the end of this month to Arello, and that is something that we could surely ask in all the different forums. Usually something happening in Tennessee is happening somewhere else.
You can keep it as like a discussion topic to keep thinking on, but I just wanted to bring it to your attention since it came up during the complaint process.
So Anna, the case you brought up earlier, or the question we sent up the flagpole earlier, that was for some title companies to disperse commissions.
Yes.
So on the state's behalf, do we feel okay if I say, hey, I'm on this app and I'm getting paid $49 if and when I ever get a call, and the broker signs something that says that's fine, I don't care if it comes through me, do we feel like that's adequate for us? If the broker's in agreement that you can get $49 if you find a client that wants to go see a house today,
I think that's
are we
what
okay
we're
with
talking
it?
about continuing the discussion about it.
Yeah.
Because what would be great is, I don't know the name of this company, but Joe, why don't you're a licensee, why don't you try and sign up? You don't have to go all the way through signing up, but at least get the information about, yes, they require the license. And how do they get paid? Those are two key things I think that we need to add to this discussion.
If I go on here and do investigations of this particular thing, do I abstain from talking about it later? Because
we're just having conversations, so it's
we
not.
need to find out about it.
Right. Yeah. So it's just we're beginning a conversation, and to see eventually probably possibly provide guidance to our licensees. So
Joe, to answer, maybe we can throw that back to our legal team.
you can work with me,
and they can.
You'll
they
be
can
my
get-
inside man.
I look forward to it.
They can be the investigators instead of us.
Questions. Is a principal broker going to fool with $49 running through his books all the time?
I wouldn't want to.
I know.
And
I wouldn't
and you know, it gives the opportunity for that person. If, in Marsha's
The
case,
splits and all that?
Well, in Marsha's case, if she's not going to come to Memphis for the cousins showing ever, so this buyer that wants to see this house theoretically could be my client now. So the broker's going to get paid on if something happens, you know, a sale or a transaction that transpires. So I would want them to go do it as much as possible.
It's just like people get paid to.
How much do they get paid?
Anything, any
I
number.
mean, 49 sounds cheap to me.
Therein lies another thing. Are they running that through the broker?
I mean, in the cases I'm saying they are. I mean, that's because it's inter-office. Yeah, but this falls under broker supervision largely, and knowing what your agents are doing, advising agents. If you do this, it's probably a licensed person. If you do it, let me know. If you do, and also it's a licensed person. But trusting your clients to them, you are opening yourself up for good things and bad things, just like anything. I think
Pros and cons.
Yeah, pros and cons. The money piece is my biggest question about it. Yeah.
You had any broker?
He did. That's how this came. It came in the form of a complaint about the app. Really, just trying to look into it. Mm-hmm.
So here's my proposal. My proposal is that we dismiss this complaint since it's not really a complaint, and we continue the discussion on the broker issue, whether the money coming through the broker issue, and I'll work with Commissioner Begley to see if what he can see on the agent side, since I, am not one. And we'll come back to have a further discussion under commission discussion about the app and see if we can give some further guidance to our licensees about
But
the
the
app.
complaint was not taken out against any licensee.
Correct.
It's
It was just
it's a principal broker, which is important to me, that is asking a good question and wanting to do what's right.
Right.
So I appreciate that, principal broker.
So thank you for
Thank
you for putting that up.
Instead of just dismissing it, I feel like we need to let the principal broker know that.
No, I will reach out to them to let them know that since it's not like an official complaint, that we're going to continue the discussion. Like, they'll get a notification that the complaint is dismissed since it's not a complaint, but we're continuing the discussion with the commission about the permissibility of the use of the app.
Further information
that they can provide to me.
Yes, will be great.
Sure.
Second.
Tucker. Motion? Those in favor say aye.
Aye.
All those opposed say no. That motion carries unanimously, 9. Okay, so this one was confusing to me. 15 and 16 are similar.
Yes, they're against individuals that work at the same location.
And I'm wondering why most property management is multifamily. So I'm wondering why, Ms. Matlock, do you think they do not need to be licensed?
I don't think that they need to be. I didn't see it. I see them as more falling into the exemption of the exemption 6213-104A1E. Specifically. So So the exemption states that as long as I'll read it. So it talks about resident managers. It's so around page 9. So it talks about a resident manager for a broker or owner that manages an apartment building or areas, are limited to supervision, exhibition of residential units, leasing or collection of security deposits, and rentals from the property. They're not permitted to negotiate the amounts of security deposits or rentals and shall not negotiate any leases on behalf of the broker. And so that is the role that I saw that the individuals were operating in.
So would that not cover most? Because if you come to me and I say, okay, $1,200, don't negotiate. I need a license to say, and then you're going to hand me a check for $12,000 for your.
Right. So property management companies are required to be licensed. So that the entity that they're working for owns the properties that they're managing.
You're managing.
So the entity that they work for, that they're the resident manager for, owns the property. So this says if a resident manager for a broker or an owner who manages an apartment building, duplex, or residential complex where their duties are limited to the supervision, exhibition of residential units, leasing or collection of security deposits, and rentals from the property. The resident manager employee shall not negotiate the amounts of security deposits or rentals and shall not negotiate any leases or on behalf of the broker. So if the individual that they were working for did not own the properties, and that is when they would be required to have a license. So if they were working for an unlicensed individual that was managing properties for others that they don't own, that is when they would be required to have a property management license.
So this would be essentially be an employee.
Right. So they're like employees. So
salaried.
like, when you work like property, like a leasing agent at an apartment complex is what I found the jobs in 15 and 16 to be analogous to.
I'm just looking at the title, the 6213. It says firm licenses for vacation lodging services, but because the text of the statute specifically lays out
so that's
duplexes
for,
and apartments and things like that.
The vacation lodging part of the statute begins at 104B, and 104A is the exemptions part. So there's two different parts of the title.
Little b.
Yes.
Okay.
So A has all of the exemptions from licensure, and then B, that has all of the requirements for our vacation lodging statutes.
I think this is the kind of thing like where a prospective tenant comes in and they see the rent and like say, well, I can't do that number. Can you do this number? That's when the leasing agent goes away and talks to the licensee.
Right. And I'll just...
if they do that.
If they do that. It contemplates it.
And just so you know, that these titles that are given are from the Tennessee Code Commission, so they don't always necessarily match what's in the text.
Yeah, I was just saying because
it's confusing.
It looks like it only goes for vacation.
The wording in the text talks about the types of apartments, multifamily units, things like that. So,
okay.
Accept. Motion to accept council's recommendation.
Okay, for 15 and 16?
Yes.
All right, we have a proper motion by Mr. Diaz. Discussion? All those in favor say aye.
Aye.
All those opposed? Motion carries 9-0. 17. This one was a complete.
Those
That the broker did not get their 120 post license, and we downgraded the license to an affiliate real estate broker, and that was council's recommendation. We accepted council's recommendation. Now the new information. So the new information. That had 50 to 80 hours out.
Sure, Frank.
Hours as of
your microphone. Sorry.
So sorry. So I'm confused about the council. You said that you did hear from the respondent March 10th by telephone.
Yes.
So they did have their 80 hours on March 10th?
Correct. So both 17 and 18. So the day that I sent the consent order, I got a call from the respondent about the these are from our outstanding 120. And the respondent stated that they did not receive the agreed citation. Was super adamant, didn't receive it. And said that, if they had received it, that they would have completed the hours.
We don't accept that.
Right. No, so.
Because that's what everybody says. They didn't receive it.
Yeah. So, that's what they stated. And, this is the italicized text is part of the information that they submitted to us about the circumstances related to the 100 and the reasons for right.
And medical issues.
Yes. And so I'll just say afterwards they decided on their own to complete the 80 hours required of the 120 hours. And so I told them that, since individuals, after they completed the hours and submitted the medical information for council's consideration and represent to you.
So this was open to end.
The agreed citations were sent out in September, and then they were given until December.
This is that group of 50.
Yes.
Okay.
And so they were given until the end of December, and then they were referred to the legal division, and we sent out, and then they were presented to you in March. And last month. And so we had the group of individuals that completed their hours, and then the group that didn't complete their hours. And those that didn't complete their hours were recommended for downgrade.
That's what this one.
Yes. And I sent the consent order, including the hours that were outstanding to the respondent.
We're still.
Yes. And the respondent sent me the letter after they completed and they have completed the hours in this letter.
But as an affiliate broker.
No, well, they don't. You remember, they have to agree to downgrade their license because it's a consent order. Correct.
But we're getting it back here at this point. So.
Right.
I think we have to be very careful right here because we have enforced this against all the other people who did not get their 120 hours, and we gave them an extended time to get their hours, and this person didn't get them still, and now they're coming back and saying, but now I have them.
Right, with, with
it's-
medical hardship, they're claiming.
then it should have come before us as a medical. I don't like this because we've done other people the same as we did this person. I mean,
I'm still trying to figure out. So, what are they asking for from us?
They want to keep their broker's license. Already downgraded.
Recommended to downgrade.
Voted.
Right. Yes.
To offer a settlement and downgrade.
Yes.
So,
Yes.
are they saying they didn't realize they accepted our recommendation?
No, so they're saying that the original agreed citation that was sent. So, like, here's the story from the beginning. So, we had a group of 50 individuals that were erroneously upgraded to brokers, but had outstanding hours left, and so we gave them 90 days to complete the remaining hours that they had left.
Grace period.
Yes, and so that the agreed citations were sent out on September 15th, and the individuals had until December 31st to complete any outstanding hours that they had. And at that point, any individuals that hadn't completed their hours, complaints were opened. Those complaints were presented before the commission last month. And so anyone whose hours were not completed at the time of presentation, the recommendation from the commission that was accepted was that their license be downgraded to an affiliate broker. And so this respondent's license was one of the recommendations for affiliate broker. And so the respondent was sent a consent order with the recommendation that their license be recommended to affiliate broker. I sent the consent order same day the respondent called me and stated they never received the consent or the agreed citation. Yes. Explained to them that it was sent in September, and told them that, the commission made the decision. They decided at that point that they were going to complete the outstanding hours in the consent that they had. So they completed the outstanding hours, and they also submitted this letter to the commission that's provided to you for consideration in the hours. And I told them that this matter would be represented to the commission, but that the commission would then determine either what would happen at that point.
So we also have to keep in mind that when you seek to upgrade your license, you effectively get 4 years to do the 120 hours because of the renewal cycle and the way it is.
And they know they have to get 120 hours. When you sit for the broker exam and you pass that broker exam, you have a certain length of time to get 120 hours. And if you don't, then you're going to lose your broker's license. So they knew that. They knew that. Not only that, not only were they sent the information, their principal broker was. This person's a broker, not a principal broker. So there's no saying I didn't get it.
And he's saying that he was the managing broker for their office in his remarks.
Was or is?
I would like to add that I'm also a licensed broker in redacted jurisdiction where I serve as the managing broker for our office.
Question. Anna, when did this person receive their broker license? It says first licensed 11/16/2006. That's affiliate, right?
Yeah, that's their affiliate license, and it looks like they upgraded their license in 2017.
2017.
Mhm.
So in the remarks, it said they have all these medical problems after I received my broker's license, which would be 2017. So that's 5 years ago. I mean, we don't have any information about when these medical things happened, do we? Other than
I just have the letter.
which says what it says here, right?
Yes.
So it doesn't say I had health issues during this time. It said since 2017. So I'm just wondering if that really is the issue. See what I'm saying?
I think regardless that we said.
Commissioner Franks, you are like down.
Are you too far?
I think you're too far away from your microphone.
Keeps going away. I just think that regardless, we've had 50 people. This is one person. The other 50 are, they either have to accept it or they don't. They'll be before us too. Do we have any other of those 50s that are saying I since got my 80 hours after the grace period?
Well, we have the next person is also another person, but their circumstance is a little different. It's about how their hours were kind of not applied.
Yeah, theirs was that they said they did it, and then we went back once the date was closed and rechecked all of them, and they said they took this course and it was not reported, and so
totally different.
Yeah. Oh, we did have one of those. Oh, okay, yes.
We do have another. Well, the other person, there are three. One person's course was not reported, but we didn't pull that one, so that one's fine. The second person, their hours, they had hours on their profile, but their license renewed at around the same time that the agreed citation went out, and so the hours that they had were applied to their renewal and not to the outstanding hours for their post 120. And the reason for that being is just because they didn't tell us that those hours should go to the 120. And so when we saw the license renewal, we just automatically applied it to the license renewal. And so we sent the consent order out, and they said, well, we had these hours afterwards. Why didn't they go to the post 120? And we explained that, most individuals in this circumstance, after they completed their hours, they notified us, and they're like, my hours have been added to CE Broker or whatever. And so we then told them, well, you didn't notify us, so we added it to your renewal and renewed your license. And so I explained to them if they would like their hours to instead go to their post 120, then that means their license would be set to expire. And then they would have to have their hours go back, whatever. Anyway.
At 18?
Yes. Were you tracking what I was saying?
Yes.
Okay. And so then their license would be expired and they would be short their renewal hours. And so that was their situation.
So really we
did.
Oh, we did?
Yes.
I don't think we pulled it.
I had 18 pulled.
Yeah.
I
We
had
need to pull
18 on my list, but it's not on the list that Caitlin gave me.
Okay.
I have 8 on my list.
Let's go back to 17.
So here's my thing for 17.
But 18 is not
It's
the
not
same
the same.
as 17.
And we need to discuss 18. So here's my devil's advocate question here. Let's say they really didn't get the notification, even though you sent it. Who knows why? They did take all the required steps immediately once they acknowledge that they knew about it, correct?
In March, not so.
Right. So
This
if
is a
they
principal
really did it,
broker, too. If it's a managing broker, it's a principal broker.
Yeah.
And they have to be held to a higher standard than as high as we have.
so how'd they get?
So I'm seeing
80
this as a
hours
third
of it.
plea for grace. That's what I'm saying.
It's another plea for some more grace that we have not extended to 47 other people.
Or anybody else that's taking the principal
Anybody
broker's
else.
now.
It's unfair to extend it to one person and not to everybody. Set aside a grace period. Give them a chance. Principal broker is not receiving their mail. Let me tell you, as a principal broker, when anything comes to my office from TREC, I'm opening it immediately to see what's going on. And, you know, I don't accept that. I don't even accept the health plea. I had cancer some years ago, and I immediately stepped down and appointed another person because I was too sick to take care of my business. So, I mean, there's things that you got to do when you have health problems too.
So I guess we need a motion. The request by this individual is to be relieved of this downgrade in their license.
Well, we don't even have to take a vote. We can just say the commission decision was made and we stick with that commission decision. Is that correct?
Yeah. Our decision stand. I'll make a motion to allow the original decision of the commission to stand.
All right, we have a proper motion by Mr. Diaz and a second by Ms. Smith to let the original decision stand on this. Do we want to have a voice vote, a roll call
That's
vote?
what Anna did just ask for.
Okay.
So,
Roll call.
okay. Okay. Commissioner Joe Begley, which would be to downgrade the license. Okay.
No.
Okay. Commissioner Jeff Diaz,
Yes.
Commissioner Steve Gwynn,
Yes.
okay. Commissioner John Moffitt,
No.
Commissioner Joan Smith, Commissioner Stacy Torbett,
No.
Commissioner Kathy Tucker, Commissioner DJ Ferris,
No.
am I missing it? Chair Marcia Franks.
Yes.
Okay.
That motion carries 5-4. Do we want to have 18? Move on to 20.
So this, Anna, the story you told us about 18 is a quirk in the reporting in CE Broker, just the timing of it.
Oh.
And there was 13 hours, not.
No, so there were 13 hours. The respondent had the 13 hours at the end. The 13 hours were applied to their renewal instead of the remaining hours required for the 120 hours.
Oh,
at
you
the end.
completed, but the education was completed by December?
Yes.
Essentially, we didn't count them because they did not communicate for us to count them, and so
Who is they?
the respondent,
The respondent.
and their renewal fell at the same time. So without the communication, the hours were used to renew the license, and in this case, you can't double dip on the hours. They can't count towards the 120 and towards the current renewal. We needed to discredit them and count them towards the 120, and then they needed to do an additional 13 for their current renewal. Does that make sense?
So
If you've taken classes in real estate, it's not very confusing.
So what they are asking us, the respondent is asking us to do, is to not downgrade their license.
Yes.
Basically, their license needs to go into an expired status, and they need to finish the additional hours towards their current renewal.
Yeah, which
And
they
they're asking
have,
us to wipe that away.
which they have done.
As
So like
for-
all of the hours are completed at this point
Both things.
for both things. So they're just asking if they can do like a retroactive switch.
Without having to expire their license.
I mean, their license won't be expired since it's been renewed, but
As
we're
what?
just.
As an affiliate, it's been renewed.
I mean, so their license, no one's license has been downgraded until they sign the consent order. So they're just saying we're saying we sent the consent order out because we applied the hours that they had on their profile to their renewal, not to their post 120.
It's basically just wording.
Right. So
They
it's
did
just like
the
a
hours.
Error,
Right.
it sounds like.
No, it's on December 30th. On December 31st, they really needed 133 hours.
No,
They-
no. So on December 31st, they had the hours. They had the hours to be done.
For a broker or affiliate?
For a broke, they had the 120 hours.
But
And so they would have, so they had the 120 hours completed.
so when did they need the additional 13?
They wouldn't. No, they don't. I'm saying the reason the consent order was sent is because we clerically applied those hours to their license renewal separately. So there was just like a breakdown in communication.
They needed those hours. Is that correct, Caitlin, or no?
Yes.
It was a failure on our part,
Oh.
on TREC's part.
It just sounds like some confusion.
No, there is confusion. So, like, the issue that I have with it is that the respondent didn't tell us that where they wanted their hours applied until we sent them a consent order, right?
Right.
But they've met all the requirements.
But
Yes.
So there's
but the
nothing
license-
outstanding.
It goes to whatever current license you have.
That's
I mean, I don't need to contact you when I have classes and say, oh, this is for my broker's license, not an affiliate license.
You
I
had
have a
been
broker's
issued
license.
an agreed citation. This person had been issued an agreed citation.
So
So you know how your license renewal opens like 2 months beforehand. So if you have CE that's like applied then, those hours would have applied to their license renewal.
is somebody seeking to upgrade their license from affiliate to broker, when they complete their 120, are they required to let you know that they've done that?
They don't have an agreed citation open against them. This all came about because of the
agreed citation.
The number that we realized the system allowed to renew without the 120. So then in September, actually, I think in August, you guys voted, let's open the complaints, offer the agreed citation, give these licensees 90 days to complete these hours. So this isn't a normal everyday circumstance.
So normal order, they got their 120, then they would have been upgraded automatically.
A majority
without having to talk
of
to
the
TREC.
other people said, hey, got the agreed citation, did the 30 hours. Can we close this out? And in those scenarios, we were able to go in, discredit the hours. Like any monthly CE that you give, you always say this doesn't count towards their continued education credit. This is sort of like that. This shouldn't have counted towards this licensee's continued education for the current cycle. What happened was they went in, renewed their license, whereas a lot of, and I'm not saying right or wrong because this is a unique circumstance, a majority of the others said, hey, I've done it. Can you review it? Can you make sure I've met the agreed citation? We reviewed them. We discredited the hours towards the current cycle like we would do with any other continued education. This is kind of, I don't even know if you really need to see this one because this is kind of just a clerical error of them doing the 13 hours before the December 31st deadline due to clerical errors and RCE automatically applying. It just applied, they renewed.
But they did not have their 120 hours by the end of December.
They did. The hours were counted towards their renewal automatically.
Which wasn't
Which
their
is
fault.
what?
Wasn't their fault.
Wasn't their fault. They could have communicated to us and said, hey, I got this agreed citation. I've done the 13 hours.
That's not a requirement that we put on them to contact us either.
I would see that they could make an assumption if they got the notification that it would automatically go.
Yes, I essentially think this one we could discredit the hours now. They've done the additional 13 towards their renewal.
Can I make a motion?
Yeah, you can make an emotion. I'm just saying, like, not saying that this person. What happened is, like, we're just saying so you guys know that you can't have your grade citation fulfilled and your license be renewed at the same time.
But they've still fulfilled both requirements.
Now, after we sent the agreed citation.
All right, I would like to make a motion that we fix it however it needs, like, what's the fix? To just reinstate their
you can
principal
dismiss
brokers?
it, but I'm just letting you know that that's what happened.
Then I make a motion
Why
to
it
dismiss.
had to come back to you.
Second.
Is it? It's not making sense. Okay.
No, I got it.
So what is your motion?
My motion
Ms.
is to
Corbett?
dismiss.
And
So that their license stays as a
dismiss
principal
what?
broker. So
Just a broker.
So our previous recommendation to downgrade, forget that. We're just, so do we dismiss it or do we make a motion to reinstate their principal broker's license?
You can.
A second.
Motion to dismiss 18 by Ms. Torbett and a second by Ms. Tucker. Any other discussion?
We're dismissing a complaint that was filed on when? In August or September? That we've already
The complaint was open in January.
January.
Yes.
Okay.
January. Complaints were open in January.
I want a voice. And then we want to
roll call.
Roll call.
Okay. I can do this. Commissioner Joe Begley. Commissioner Jeff Diaz.
Yes.
Commissioner DJ Ferris. Commissioner Steve Gwynn.
Yes.
Commissioner John Moffitt. Commissioner Joan Smith. Commissioner Stacy Torbett.
Yes.
Commissioner Kathy Tucker.
Yes.
Chair Marcia Franks.
yes. That motion carries unanimously 9-0. Okay, let's move on to number 21, Ms. Smith.
Money in before.
Keeps us straight, doesn't it? This is a Facebook ad.
Carry over.
I'm listening. All under contract.
The original listing agent that had the contract with the seller was the one who negotiated the contract for the sale. Yes, ma'am. And
Of what you have.
False represent.
I'm clear on. But your recommendation is for
$1,000.
inducing any party to a contract sale or lease to break the contract.
respondent then is a different affiliate broker or realtor, and then approached the homeowner and said, "Oh, hey, yes, ma'am."
Inducement.
Okay, I move recommend it.
Proper motion by Ms. Smith and a second. Profit. Other discussion?
So this case is related to number 43.
Yes.
Can I ask? I noticed in there were several places in here that there are cases that are similar or like or have to do with other cases. Is it possible to have them one after the other, or are y'all putting them in here according to their number, their case number? I wasn't sure how you put them in order. If there was a
This being my first legal report for the commission, I would prefer, like what you just said, to put the corresponding or related complaints next to each other. The draft of the report that was very helpfully provided by Ms. McGinn, it was prepared that way, and so I wasn't sure stepping in if I could move them around. I'm happy to do that. I think that also makes more sense for you to see them next to each other. So
yeah, that would be good.
Yes, ma'am.
All right,
So does the motion then conclude 21 and 43?
No,
Okay.
43 wasn't pulled.
Okay. I'm just want to make sure.
All right, so the motion is to accept council's recommendation of a $1,000 civil penalty. Motion made by Ms. Smith and seconded by Mr. Moffett. Anything else? All those in favor say aye.
Aye.
Any opposed? Say no. That motion carries unanimously, 9-0. All right, and failure to respond. Made by a real estate firm, it's the principal broker requirement to on back to it. Only the principal have another agent.
It can be the principal broker. I don't think there's not a.
Can be the owner who. What we're looking at.
I mean, it doesn't. There's nothing that says specifically it should be the principal broker, but it should be. But like technically, their attorney could respond.
Right.
But it should likely come from a licensee.
So this
They're not.
well, this goes firm. So the firm.
Right.
Up to them to decide who signs.
Right. So if we send it to a firm, it's made out. a civil penalty, a check from the principal broker or somebody that represents.
27 and 20 are two separate complaints
Yes, ma'am. One
about
was
the same thing.
Yes, ma'am. One was from a private citizen that was she was a seller. It was a seller. The other one was from the affiliate agent that was representing the seller.
There can be two.
There's no response to either.
I mean, and you did the right thing. I mean, whenever that happens, we have just always had $1,000 if you're not going to respond. So,
Can we group these two together?
No.
We can't. So we can't say 27 and 28 accept council's recommendation.
Well, I mean, we could. You mean on the vote?
Yeah.
Yes. I mean, I'm okay with that if y'all are okay with
Can
that.
we do that? All right. Then I make a motion to accept council's recommendation on 27 and 28 of each case $1,000 civil penalty for failure to respond.
Second.
Made by Ms. Torbert and as council's recommendations of an $1,000 civil penalty for each case. All right. Any other discussion? All those in favor say aye.
Aye.
Those opposed say no. That motion carries unanimously 9-0. We're down to our last case, number 32. And that one is a discussion. Want to tell us something about Kimberly?
Kim is fine. Yes, ma'am. This is a bit drama-filled, but we have two individuals that were in a partnership of sorts that purchased this property. About a year later, the partnership expires, so to speak. In the interim, they have entered, or the property owner, and there's only one property owner who is on the deed and is on the listing agreement, enters into this listing agreement with a mutual friend. The mutual friend, even after this partnership expires, continues to involve this third party who is not their client, who is not on any deed, who is not on any contract, in negotiations, even after the client has said, stop doing that, they're not involved anymore. Once the listing has expired, the complainant had to take extraordinary steps up to and including the principal broker more than once to say, I do not have this relationship with your affiliate realtor anymore. I want this listing removed. I want to be able to list it with somebody else before that was finally done. So there seems to be, as I discussed with Ms. Matlock, a very, I was disturbed at the breach of duty that this respondent paid or continued to act against really the best interest of the contracted client.
So do you violation of the code, and if so, what?
404 violation, 6213-404. So declined. I was not sure. I do not have the book yet, so I can't tell you what page. I'm just looking at the statute itself.
Longer, niece.
I'm working on that right now, but I'm doing the old-fashioned Westlaw way here in front of me. So,
6213-404. You're right.
Yeah.
What it
The
says.
licensee's client.
it also, as a licensed professional who knows about fiduciary duty to your clients, it disturbed me even more that as part of the response, the respondent, in support of their response, submitted a letter from this third party, and that just, to use a phrase, crawled all over me, that they still thought it was okay for this person to interplead in some way in the response.
The question is, what is the if old not using best violation of reason? Trying to figure out what it all ended well, correct? everybody's mad at each other.
It does sound like the
But it
respondent
ended.
represented another buyer. Respondent was still part of the deal. So it sold, and it looks like it sold, but the respondent represented a separate buyer. And so the complainant is just saying,
The respondent act.
what is the complaint saying here? Right.
Repeatedly.
Repeat it, yeah.
And it alleges that offers were not conveyed to them promptly, that they did not act in the interest of the client.
So it's duty owed to licensed client, and it's also skill and care.
Right. Kim is telling us that she 404 paragraph 1 made a lawful law instructions.
And 2, be loyal to the interest. What I want and what I recommend. I see 2 distinct violations here of obeying all lawful instructions and being loyal to the interest of the client. And so I would ask for at least $1,000 penalty on each. I think this is some egregious behavior.
And you started this conversation with a lot of drama. So you feel like taking out the drama and getting through the muddy waters,
Yes, sir.
you still feel like they deserve fines. Okay.
I was just asking. I'll make a motion to both of those that you just said, which I can't remember what they are, but I will say 500 for each, so a total of 1,000. You may restate.
Find this respondent to find violations of section 621344 parts 1 and 2 and offer a civil penalty of $500 on each. Promotion.
I'll second that.
Discussion. What about the principal broker? Did he or she not help? It didn't seem like it.
I have very limited information on that. Only what I have is from the complainant that when they finally were able to get through to the principal broker and discuss the issue with them, that counsel here is suggesting that perhaps we didn't and get their response from me, but they knew.
So do we need to add that to the motion or
So
do
can
it?
I amend my motion to open a complaint against the principal broker, but we'll still have the same complaint?
If you'd like to, yes.
Sure.
Kathy.
So to recap, we're at 500 per violation against the respondent and open a complaint. Yes, 500 each, rather than her. She said 1,000. Kimberly did, and then open a complaint against the principal broker for what?
Failure to supervise.
Failure to supervise. Okay.
All those in favor of the motion say aye.
Aye.
All those opposed say no. All right, and I say no on it also, so motion carried. All right.
Heard no.
Okay.
Oh, okay. We couldn't hear you, Joan.
All right, that concludes the legal report. Next is the commission discussion, commissioner education topics.
We just put this on the agenda because we had been kind of doing our topics that we were updating the commission on each month. And we ran out of topics. And so we just wanted to see if there was any other subjects that you would like us to add going forward. We do still plan to do a sunshine update, but we have to wait for the approved departmental presentation on that.
So we're not doing that in May.
Yeah, no.
No.
I respectfully say that I feel very educated after yesterday's exam question review.
But it's not until June, DJ. So
yeah, June I'll be ready for something else to learn.
Do you have are you affiliated or a broker?
I'm a broker.
Oh shoot! I was going to say if you're an affiliate, it's time to go get your brokers tomorrow after going over all the questions. Okay. All right. So, are you wanting us to suggest another?
I'm not saying you need to suggest any, but I'm saying if you ever have a light bulb go off of a topic you want more information on, you can email us. We can add it later. But at this point, we have gone through the initial topics that were requested, and so.
So, as a matter of fact, we have another topic.
Okay.
At 10:10 a.m. today, there were 27 vacant parking spots in this parking lot right here. 26. We would like to ask, and we'll put it in writing if we need to put it in writing, for 9 spots on 10 different occasions during the year for the commission.
That is not up to me. I don't park there. I don't get to park there. I've never gotten to park there.
Make that 11, 10, 11. Well,
so you are vocalizing
who should we address the
it.
letter to, if not you?
I don't know.
Like me to take. Well, somebody has to be in charge of the parking here, and if the parking lot were full, that would be different. But since I've been on the commission, the parking lot is never full. We were able to park here, then we can't park here, so we're parking across the street, down the road, under the railroad tracks. Or paying to park, which is fine on a day like today. But when it's raining, it's I don't know. I would like some clarification maybe about why we can't.
It would. Oh.
So you're saying we'll have to address that on our end?
I'm just saying that I am only communicating and only implementing what is being told to me by our division department. So.
I feel like we could.
I'll deal with it. I'll take it on.
You see what you can find out, and we'll discuss it.
Okay.
Oh, no harm, no foul. No, all you can say is all they can say is no.
The worst they could do is say no. You still have to park across the street. Although Marcia ended up with $100 fine from the last. She had a wrong tag number, so she paid to park and then got $100 parking fine in addition to pay.
Okay, so thank you to everybody that came. Aren't you glad that we're finished at 11:34 and you're going to get 8 hours of credit? And is this all Berkshire Hathaway, or are there other offices represented here today? Berkshire Hathaway. Good for y'all. We really appreciate you being here. And we appreciate people who are wanting to do the right thing. I promise you, I've had a license over 30 years, and I've learned more at the commission meetings than I ever knew. So even when I roll off this summer, I'm going to feel like I'm going to have to keep watching the meetings to even keep up, because you've been able to see today what matters to the commission and what really is not on our radar. So I do want to thank your office. And who's your principal broker? Thank you for having them come too. We appreciate you. And she's not getting paid enough, no matter what she's getting paid. All right. Anybody else have anything that we want to say or mention? Motion to adjourn. All those in favor, say aye. Thank you, everyone, for coming.
See y'all in West Tennessee.
Yep.
Something for the best.
Bye. Are we having a dinner?
Hey, don't forget, we got a sandwich back there.
That may linger for a little bit. Well, I thought I was going to be here all day, so I'm like, I'm not in a rush now. I can go to the mall. I think so. I'm go shop.
I was staying. I mean, I had dinner with Alex.
Safe travels, everybody. Safe travels.
Be sure and sign out, everyone. Be sure and sign out.